Question 1. When implementing new protocols in a shared environment where various jurisdictions must coordinate their election processes, a dispute arises regarding the application of Section 2 of the Voting Rights Act of 1965. A state enacts a new voter identification requirement that disproportionately impacts minority voters. A legal challenge is filed arguing that the law results in racial discrimination. Which of the following standards will the court most likely apply to determine if the voter ID law violates Section 2? A. The intent standard, requiring proof that lawmakers enacted the law with discriminatory purpose. B. The results test, assessing whether the law has discriminatory effect on minority voters, even if unintentional. C. The rational basis test, determining if the law has reasonable relationship to legitimate state interest. D. The strict scrutiny test, requiring the law to serve compelling government interest and be narrowly tailored. Answer B. The results test, assessing whether the law has discriminatory effect on minority voters, even if unintentional. Explanation. Under Section 2 of the Voting Rights Act of 1965, courts evaluate whether voting law results in racial discrimination, even if no discriminatory intent is proven. This is known as the results test, which was reinforced in the case Thornburg v. Jingles, 1986. Considered unlawful if it disproportionately hinders minority voters from participating in the electoral process. Option A. Intent standard is incorrect because while intentional discrimination is unconstitutional, Section 2 focuses on the effect rather than intent. Option C. Rational basis test is incorrect because voting rights cases often require a higher level of scrutiny. Option D. Strict scrutiny test applies to fundamental rights but is not the primary test under Section 2 unless the law directly burdens constitutional rights such as racial classifications. Thus, courts apply the results test to determine if law disproportionately impacts minority voters, making option B the correct answer. Question 2. During a comprehensive review of a process that needs improvement, a state legislature decides to redraw congressional districts after the census results are released. Civil rights organizations file a lawsuit claiming the new district map is an example of racial gerrymandering, violating the Equal Protection Clause of the 14th Amendment. Which of the following legal precedents is most relevant in determining the validity of the claim? A. Bush v. Gore 2000, related to equal protection in ballot recounts. B. Shaw v. Reno 1993, concerning race-based redistricting. C. Citizens United v. Feck 2010, focused on campaign finance laws. D. McConnell v. Feck 2003, concerning soft money contributions. Answer B. Shaw v. Reno 1993, concerning race-based redistricting. Explanation. In Shaw v. Reno 1993, the Supreme Court ruled that race-based redistricting must pass strict scrutiny under the Equal Protection Clause. The court stated that districts drawn predominantly on racial considerations must serve compelling government interest and be narrowly tailored. The claim in this scenario closely aligns with precedent set in Shaw v. Reno. Option A. Bush v. Gore is incorrect because it deals with recount procedures and not racial gerrymandering. Option C. Citizens United v. Feck is incorrect as it pertains to corporate political spending, not districting. Option D. McConnell v. Feck is also incorrect since it focuses on campaign finance reform, specifically the Bipartisan Campaign Reform Act (BCRI). Therefore, courts analyzing racial gerrymandering claims rely on Shaw v. Reno, making option B the correct answer. Question 3. In a high-stakes environment where multiple challenges arise due to discrepancies in electronic voting machines, a legal challenge is filed questioning the constitutionality of the state's reliance on direct recording electronic (DRE) voting systems without voter-verified paper audit trail (VVPAT). The plaintiffs argue that the lack of paper trail violates voters' rights by failing to ensure an accurate count and impeding post-elect audits. What is the strongest constitutional argument supporting this claim? A. Violation of the 14th Amendment's Equal Protection Clause, arguing that some voters are treated differently based on the voting method used. B. Violation of the First Amendment's Free Speech Clause, arguing that the inability to verify votes suppresses political expression. C. Violation of the Sixth Amendment's right to fair trial, arguing that election integrity affects due process in legal proceedings. D. Violation of Roteke Omento's Section 1 of the Constitution, arguing that the state has failed to properly appoint electors. Answer: a violation of the 14th Amendment's Equal Protection Clause, arguing that some voters are treated differently based on the voting method used. Explanation: the Equal Protection Clause of the 14th Amendment has been invoked in election cases to challenge voting disparities, most notably in Bush v. Gore 2000. Courts have ruled that when states implement inconsistent voting technologies or procedures that lead to unequal treatment of voters, it may constitute an equal protection violation. Option B, First Amendment claim, is incorrect because voting integrity is generally analyzed under equal protection, not free speech. Option C, Sixth Amendment claim, is incorrect because the right to fair trial applies to criminal proceedings, not election law. Option D, Vertigo Omen to Action 1 claim, is incorrect as this provision governs the selection of presidential electors, not the mechanics of voting technology. The strongest constitutional argument is based on equal protection concerns, making option A the correct answer. Question 4. In a high-stakes environment where multiple challenges intersect, a state legislature is considering changes to its voter ID laws. The proposed bill would require all voters to present a state-issued photo ID to vote in person and would also apply to absentee voting. However, concerns have been raised that this law could disproportionately affect elderly voters, low-income individuals, and racial minorities who may face obstacles in obtaining IDs. Given this scenario, which legal precedent or federal law would most likely be invoked in challenging this legislation? A. National Voter Registration Act of 1993 and VRA. B. Voting Rights Act of 1965, Section 2. C. Bipartisan Campaign Reform Act, McCain-Feingold Act. D. Reapportionment Act of 1929. Answer: B. Voting Rights Act of 1965, Section 2. Explanation: why B is correct. Section 2 of the Voting Rights Act prohibits voting practices that result in discrimination based on race or ethnicity. Courts analyze whether a law imposes a disproportionate burden on minority voters even if there is no overt discriminatory intent. The Supreme Court in Yarovich v. Democratic National Committee 2020 considered the impact of such laws on minority groups. YA is incorrect. The National Voter Registration Act in VRA primarily governs voter registration processes including mail-in registration and voter roll maintenance. While it impacts access to voting, it does not directly regulate voter ID requirements. YC is incorrect. The Bipartisan Campaign Reform Act, McCain-Feingold Act, deals with campaign finance and advertising, not voter ID laws. YD is incorrect. The Reapportionment Act of 1929 determines how seats in the U.S. House of Representatives are allocated among states after each census. It is unrelated to voter ID laws. This question tests the student's ability to recognize how voting rights laws interact with state election policies and how courts analyze potential discriminatory impacts. Question 5. During an emergency response where multiple areas are impacted, a major cyber attack disrupts the electronic voter registration system in a swing state 1 week before the presidential election. The governor declares a state of emergency and authorizes same-day voter registration at all polling locations, which is not typically allowed under state law. Opponents argue that this decision violates federal election law and constitutional provisions. Which legal principle is most relevant in determining whether the governor's action is lawful? A. Article I, Section 4 of the U.S. Constitution Elections Clause. B. Help America Vote Act of 2002, HIVA. C. National Voter Registration Act of 1993 and VRA. D. Federalism and state control over elections. Answer: A. Article I, Section 4 of the U.S. Constitution Elections Clause. Explanation: while A is correct, the Elections Clause of the U.S. Constitution gives states broad authority to regulate elections but allows Congress to intervene in setting election laws. If challenged, courts would evaluate whether the governor's emergency action aligns with constitutional principles and federal election laws. Why B is incorrect. The Help America Vote Act, HIVA, establishes guidelines for voting systems and election security but does not address whether the governor can unilaterally change rules in an emergency. Why C is incorrect. The National Voter Registration Act and VRA promotes voter registration access but does not regulate emergency powers for modifying election procedures. Why D is incorrect. While federalism grants states control over elections, it does not override constitutional provisions or federal election law. This question examines how emergency powers intersect with federal election law, constitutional authority. Question 6. In a situation where formal requirements conflict with practical considerations, a candidate for the U.S. Senate has met all federal filing requirements but is disqualified under state law due to a failure to submit a notarized declaration of candidacy. The candidate argues that state laws cannot impose additional burdens beyond federal requirements. What legal doctrine would most likely be applied in this case? A. Supremacy clause. B. Equal protection clause. C. First Amendment right to political association. D. 10th Amendment state sovereignty. Answer: A. Supremacy clause. Explanation: why A is correct. The Supremacy Clause, Article Romans Clause 2 of the U.S. Constitution establishes that federal law overrides conflicting state law. If a state law imposes additional restrictions beyond what federal law requires for federal office eligibility, it could be struck down. Why B is incorrect. The Equal Protection Clause, 14th Amendment, applies to cases of discrimination rather than conflicts between federal and state election laws. Why C is incorrect. The First Amendment protects political association rights but does not override federal election laws. Why D is incorrect. The 10th Amendment grants states powers not delegated to the federal government, but it does not allow states to impose additional qualifications on federal candidates. This question helps students understand the limits of state power over federal elections. Question 7. When implementing new protocols in a shared environment, a state legislature passes a law requiring election officials to post the names of all voters who cast absentee ballots online after an election. The law is challenged as unconstitutional. What is the strongest legal argument against this requirement? A. First Amendment right to free speech. B. 14th Amendment Equal Protection Clause. C. Right to a secret ballot and voter privacy protections. D. Commerce Clause of the U.S. Constitution. Answer: C. Right to a secret ballot and voter privacy protections. Explanation: why C is correct. The right to a secret ballot is a fundamental principle in U.S. elections. Publishing voter names risks intimidation and retaliation, violating privacy protections under election laws such as the Help America Vote Act, however, and other state-specific secrecy laws. YA is incorrect. While the First Amendment protects free speech, it does not directly apply to a law exposing voter identities. YB is incorrect. The Equal Protection Clause applies to discrimination but does not specifically protect anonymity. YD is incorrect. The Commerce Clause regulates interstate commerce and is unrelated to voter privacy. This question challenges students to evaluate constitutional protections of voter secrecy. Question 8. When implementing new protocols in a shared environment, a state election board mandates that all voting machines be equipped with blockchain-based audit trails. However, a lawsuit is filed arguing that this requirement creates an undue burden on state and local election officials. What legal principle would most likely be at issue in determining whether this requirement is enforceable? A. Article Omen to Section 1 of the U.S. Constitution, Electoral College Clause. B. Article I, Section 4 of the U.S. Constitution, Elections Clause. C. The First Amendment, Freedom of Speech and Expression. D. The 10th Amendment, State Sovereignty over Elections. Answer: B. Article I, Section 4 of the U.S. Constitution, Elections Clause. Explanation: why B is correct. The Elections Clause gives state legislatures the power to regulate elections, but Congress may also impose requirements. If a federal mandate interferes with state control beyond constitutional limits, courts might deem it an overreach. YA is incorrect. The Electoral College Clause pertains to presidential elections and the selection of electors, not the regulation of ethnology. YC is incorrect. While the First Amendment applies to political speech and campaign regulations, it does not directly impact election administration laws. YD is incorrect. The 10th Amendment does protect state powers, but the Elections Clause, Article I, Section 4, is more directly applicable. This question tests understanding of federal versus state authority in election administration. Question 9. During a critical transition period where existing processes are being reviewed, a newly passed state law allows political parties to station poll monitors inside all voting locations. Civil rights organizations argue that this law could lead to voter intimidation, especially in minority-dominated precincts. What is the strongest constitutional challenge against this law? A. First Amendment, right to free speech and assembly. B. 14th Amendment, Equal Protection Clause. C. 15th Amendment, prohibition of racial discrimination in voting. D. 24th Amendment, ban on poll taxes. Answer B. 14th Amendment. Equal Protection Clause. Explanation why B is correct. The Equal Protection Clause prohibits election practices that disproportionately burden certain voters. If poll monitoring is used to target minority communities unfairly, it may be unconstitutional. YA is incorrect. The First Amendment protects free speech but does not prevent laws restricting potential voter intimidation. YC is incorrect. The 15th Amendment bans discrimination in voting but is often enforced through the Voting Rights Act, VRA, rather than a direct constitutional claim. YD is incorrect. The 24th Amendment prohibits poll taxes but does not apply to poll monitoring laws. This question challenges students to evaluate voter intimidation and equal protection concerns. Question 10. In a high-stakes environment where multiple challenges intersect, a state enacts a law banning mail-in voting except for military personnel and disabled individuals. Advocacy groups sue, claiming the law violates federal voting rights protections. Under what federal statute is this lawsuit most likely to be filed? A. Voting Rights Act of 1965. B. National Voter Registration Act of 1993. C. Uniformed and Overseas Citizens Absentee Voting Act UOCAVA. D. Help America Vote Act of 2002. Answer A. Voting Rights Act of 1965. Explanation. YA is correct. The Voting Rights Act VRA prohibits voting laws that disproportionately affect racial minorities. If the restriction disproportionately impacts minority voters, it could be challenged under Section 2 of the VRA. YB is incorrect. The NVRA governs voter registration but does not mandate mail-in voting. YC is incorrect. UOCAVA applies to military overseas voters but does not address broader restrictions on mail-in voting. YD is incorrect. HIVA improves election administration but does not provide grounds to challenge state mail-in voting restrictions. This question examines federal protections against discriminatory election laws. Question 11. While analyzing the root causes of sequential problems in voter turnout, a city council proposes to eliminate early voting due to concerns about election security. However, this change is predicted to significantly impact voters who rely on weekend voting opportunities. What legal argument could most effectively challenge this decision? A. Article Amendment to Section 1. Electoral College Clause. B. 14th Amendment. Equal Protection Clause. C. First Amendment. Freedom of political expression. D. 12th Amendment. Presidential election procedures. Answer B. 14th Amendment. Equal Protection Clause. Explanation why B is correct. If early voting restrictions disproportionately affect certain groups, e.g., working class voters or racial minorities, it could be challenged under the Equal Protection Clause. YA is incorrect. The Electoral College Clause governs the selection of electors, not voter access issues. YC is incorrect. The First Amendment protects free expression, but voting rights are more directly governed. The 14th Amendment. YD is incorrect. The 12th Amendment outlines presidential election procedures, not early voting laws. This question tests discriminatory impacts of voting restrictions. Question 12. During an emergency response where multiple areas are impacted, the governor issues an executive order extending absentee ballot deadlines due to a natural disaster. Opponents argue that the governor has no legal authority to change election deadlines. Which legal principle is most relevant in determining the validity of this executive order? A. 10th Amendment. State sovereignty. B. Article I, Section 4. Elections Clause. C. 26th Amendment. Voting age protections. D. Federal Election Campaign Act, FACA. Answer B. Article I, Section 4. Elections Clause. Explanation why B is correct. The Elections Clause gives states control over election procedures. However, whether the governor can unilaterally alter election deadlines depends on state law. YA is incorrect. The 10th Amendment supports state authority but does not override constitutional election provisions. YC is incorrect. The 26th Amendment protects voting rights aged 18, but it does not apply to election deadlines. YD is incorrect. FECA regulates campaign finance, not election procedures. This question examines executive authority over election changes. Question 13. During a major transformation where existing methods are being reevaluated, a state legislature passes a law requiring all voters to show government-issued photo ID at polling places. Civil rights organizations challenged the law, arguing that it disproportionately disenfranchises minority and low-income voters. which constitutional principle is most relevant in assessing this law? A. 14th Amendment, Equal Protection Clause. B. 10th Amendment, State Sovereignty. C. First Amendment, Freedom of Speech. D. 26th Amendment, Right to Vote at 18. Answer A. 14th Amendment. Equal Protection Clause. Explanation. Why A is correct. The Equal Protection Clause requires that voting laws apply fairly to all citizens. If voter ID laws disproportionately burden specific groups, they can be challenged under this amendment. Why B is incorrect. The 10th Amendment allows states to regulate elections, but state power is still subject to constitutional limits, such as equal protection. Why C is incorrect. The amendment protects free speech but does not directly govern election access. Why D is incorrect. The 26th Amendment ensures voting rights at age 18 but does not regulate voter ID laws. This question examines the balance between election security and voter access. Question 14. When developing a solution that must address opposing needs, election officials propose switching from electronic voting machines to hand-marked paper ballots to enhance election security. However, disability rights advocates argue that this change violates federal law. Which law is most relevant in assessing this claim? A. Voting Rights Act of 1965. B. Help America Vote Act of 2002, HAVA. C. National Voter Registration Act of 1993, NVRA. D. Bipartisan Campaign Reform Act of 2002, BRI. Correct answer. B. Help America Vote Act of 2002, HAVA. Explanation. Why B is correct. HAVA mandates that voting systems be accessible to individuals with disabilities, including the ability to vote independently. A move to all paper ballots could violate this requirement. Why A is incorrect. The VRI protects against racial discrimination in voting, but does not specifically mandate accessible voting technology. Why C? Incorrect. The NVRA regulates voter registration, not ballot accessibility. Why D is incorrect. The BCRI focuses on campaign finance, not voting methods. This question highlights voting technology, accessibility, and compliance with federal law. Question 15. While examining inconsistencies across various units, election officials discover that some counties are rejecting significantly more mail-in ballots than others due to signature matching policies. A legal challenge is filed arguing that this practice violates which constitutional protection? A. Article Amendment to Section 1. Electoral College Clause. B. 14th Amendment. Due Process and Equal Protection Clauses. C. 24th Amendment. Prohibition of poll taxes. D. First Amendment. Right to petition the government. Answer B. 14th Amendment. Due Process and Equal Protection Clauses. Explanation. Why B is correct. In Bush v. Gore 2000, the Supreme Court ruled that inconsistent election practices can violate equal protection. The Due Process Clause also applies if voters are denied fair procedures. Why A is incorrect. The Electoral College Clause pertains to presidential elections, not ballot rejection policies. Why C is incorrect. 24th Amendment bans poll taxes, but does not govern ballot rejection rules. Why D is incorrect. The First Amendment does not directly regulate election administration. This question tests procedural fairness in election administration. Question 16. During an emergency response where multiple areas are impacted, a state allows online voting for voters displaced by a natural disaster. A lawsuit is filed claiming that online voting increases the risk of fraud and should be prohibited. What is the strongest constitutional defense for the state's action? A. 14th Amendment. Equal Protection Clause. B. 10th Amendment. State Sovereignty. C. Article I, Section 4. Elections Clause. D. Help America Vote Act of 2002, HAVA. Answer C. Article I, Section 4. Elections Clause. Explanation. Why C is correct. The Elections Clause gives states the power to regulate voting methods, including emergency measures like online voting. Why A is incorrect. The Equal Protection Clause is more relevant to discrimination claims, not state authority over voting methods. Why B is incorrect. The 10th Amendment grants general state authority but does not override specific constitutional provisions like the Elections Clause. Why D is incorrect. HIVA sets election administration guidelines but does not mandate or prohibit online voting. This question highlights state authority in emergency election procedures. Question 17. In a situation where formal requirements conflict with accessibility needs, a city implements a policy requiring all polling places to be in government buildings, eliminating locations in private community centers. A lawsuit is filed claiming the new rule violates federal law. Which law is most relevant? A. Americans with Disabilities Act, ADA. B. National Voter Registration Act, NVRI. C. Voting Rights Act of 1965, VRA. D. Fair Housing Act, FHA. Answer A. Americans with Disabilities Act, ADA. Explanation. Why A is correct. The ADA requires polling places to be accessible to individuals with disabilities. Eliminating community centers could reduce accessibility. Why B is incorrect. The NVRI covers voter registration, not polling place locations. Why C is incorrect. The VRA prohibits racial discrimination but does not govern polling place accessibility. Why D is incorrect. FHA regulates housing discrimination, not voting locations. This question tests accessibility laws and polling place requirements. Question 18. While managing a hybrid approach where timing issues arise, the state allows election officials to process but not count mail-in ballots before Election Day. A legal challenge argues that this practice conflicts with federal election laws. Which law is most relevant? A. Help America Vote Act, HAVA. B. National Voter Registration Act, NVRI, CU. S. Constitution, Article Omen to Section 1. D. Federal Election Campaign Act, FECA. Answer A. Help America Vote Act, HAVA. Explanation. Why A is correct. HAVA provides guidelines for election procedures, including ballot processing. It does not prohibit pre-election day processing. Why B is incorrect. The NVRA regulates voter registration, not ballot processing. Why C is incorrect. Article Omen to Section 1 governs presidential elections, not ballot counting procedures. Why D is incorrect. FECA governs finance, not election administration. This question highlights state flexibility in ballot processing. Question 19. In a situation where formal requirements conflict with practical voting accessibility, what is the best approach to ensure both security and voter participation? A. Strictly enforce voter ID laws without exceptions. B. Eliminate voter ID requirements entirely to maximize accessibility. C. Implement voter ID laws with alternative verification methods for those lacking proper documentation. D. Require all voters to vote in person, eliminating mail-in ballots and early voting. Answer C. Implement voter ID laws with alternative verification methods for those lacking proper documentation. Explanation. A balanced approach ensures election security while avoiding voter suppression. Alternative verification methods, such as affidavits or provisional ballots, help voters without an ID prove their eligibility. Option is incorrect because strict voter ID laws may disenfranchise eligible voters, especially minorities, the elderly, and those in rural areas. Option B is incorrect because eliminating voter ID requirements could raise concerns about election integrity. Option D is incorrect because requiring in-person voting excludes many eligible voters, such as those with disabilities or living abroad. Question 20. While analyzing the root causes of sequential problems in voter registration, officials discovered discrepancies in state databases. What is the most effective way to address these inconsistencies? A. Purge voter rolls immediately to remove all duplicate registrations. B. Implement a centralized database that integrates with state election systems and updates voter records securely. C. Require all voters to re-register before every election to ensure accuracy. D. Ignore the discrepancies since they may not impact overall election results. Answer B. Implement a centralized database that integrates with state election systems and updates voter records securely. Explanation. A centralized, secure, and regularly updated database ensures that voter records remain accurate across states, reducing duplicate registrations and fraud risks. Option is incorrect because purging voter rolls without safeguards could wrongfully remove eligible voters. Option C is incorrect because requiring re-registration before every election creates unnecessary barriers. Option D is incorrect because even minor discrepancies can affect voter confidence and election integrity. Question 21. When implementing backup procedures across various polling stations, what is the most effective contingency plan to ensure smooth voting operations? A. Have emergency paper ballots available in case of electronic voting machine failures. B. Rely solely on electronic machines, assuming failures will be minimal. C. Close polling stations experiencing technical difficulties and ask voters to return later. D. Delay the election until all technical issues are resolved. Answer A. Have emergency paper ballots available in case of electronic voting machine failures. Explanation. Emergency paper ballots prevent long delays and ensure all voters can cast their ballots even if electronic machines fail. This maintains voter confidence and prevents disenfranchisement. Option B is incorrect because relying solely on electronic machines ignores the risk of technical failures. Option C is incorrect because closing polling stations and asking voters to return later creates accessibility issues. Option D is incorrect because elections cannot be delayed due to technical issues in most jurisdictions. Question 22. During a comprehensive review of a process that needs improvement, election officials identify long wait times at polling places. What is the best approach to address this issue? A. Increase the number of voting machines and polling staff at high traffic locations. B. Limit the number of voters at each polling station to reduce congestion. C. Reduce early voting to encourage voters to participate only on election day. D. Eliminate in-person voting and require all voters to submit mail-in ballots. Answer A. Increase the number of voting machines and polling staff at high-traffic locations. Explanation. More voting machines and staff help speed up the process, reduce wait times, and ensure a smooth voting experience. Option B is incorrect because limiting voters per location creates unnecessary barriers. Option C is incorrect because reducing early voting increases congestion on election day. Option D is incorrect because eliminating in-person voting removes voter choice and may not be feasible for all voters. Question 23. In a high-stakes environment where multiple challenges arise, a state enacts a law requiring all voters to provide proof of citizenship before registering to vote. Civil rights organizations challenge the law, arguing that it violates federal voter registration requirements. Which federal law is most relevant to this challenge? A. Voting Rights Act of 1965. B. National Voter Registration Act of 1993, NVRA. C. Help America Vote Act of 2002, HAVA. D. Bipartisan Campaign Reform Act of 2002, ARI. Answer B. National Voter Registration Act of 1993, NVRA. Explanation. Why B is correct. The NVRA establishes federal voter registration requirements for elections. It prohibits states from requiring excessive documentation that could hinder voter registration. YA is incorrect. The Voting Rights Act, VRA, primarily addresses racial discrimination, not documentation requirements for voter registration. C is incorrect. The HAVA focuses on election administration but does not set voter registration rules. D is incorrect. The BCRI regulates campaign financing, not voter registration. This question examines voter registration laws and federal-state conflicts. Question 24. While investigating a complicated issue between different agencies, a state election board finds that voter registration rolls have not been updated, leading to ineligible voters receiving ballots. A lawsuit argues that election officials violated federal law by failing to maintain accurate voter lists. Which law is most relevant? A. National Voter Registration Act, NVRA. B. Federal Election Campaign Act, FECA. C. Voting Rights Act of 1965. D. 24th Amendment. Answer A. National Voter Registration Act, NVRA. Explanation. YA is correct. The NVRA requires states to maintain accurate and up-to-date voter rolls, removing ineligible voters while protecting against wrongful purges. B is incorrect. The FECA focuses on campaign finance, not voter roll maintenance. C is incorrect. The VRA addresses voter discrimination, not voter roll accuracy. D is incorrect. The 24th Amendment bans poll taxes but does not regulate voter list maintenance. This question explores election integrity and compliance with federal law. Question 25. During a comprehensive review of a process that needs improvement, a study finds that polling places in urban areas have fewer voting machines per voter compared to rural areas, leading to longer wait times. What constitutional principle is most relevant to this issue? A. Equal Protection Clause of the 14th Amendment. B. Supremacy Clause of Article Omen First Amendment. Freedom of speech. D. 10th Amendment. State sovereignty. Answer A. Equal Protection Clause of the 14th Amendment. Explanation. YA is correct. Unequal allocation of voting resources can disproportionately burden certain voters, potentially violating the Equal Protection Clause. B is incorrect. The Supremacy Clause establishes federal law as supreme but does not apply directly to voting resource allocation. Why C is incorrect. The First Amendment protects speech but does not govern polling. Accessibility. Why D is incorrect. The 10th Amendment allows state control over elections but does not override equal protection rights. This question tests fair election administration and constitutional principles. Question 26. When scaling up operations that experience significant growth, a state allows same-day voter registration to accommodate increased turnout. Critics argue that this could lead to voter fraud. Which law provides guidelines for voter registration procedures? A. Help America Vote Act, HIVA. B. National Voter Registration Act, NVRA. C. Voting Rights Act of 1965. D. Federal Election Campaign Act, FECA. Answer: B. National Voter Registration Act, NVRA. Explanation: why B is correct. The NVRA governs voter registration, including the ability of states to adopt same-day registration policies. Why A is incorrect. The HIVA focuses on election procedures but does not regulate voter registration methods. Why C is incorrect. The VRA prevents racial discrimination but does not address registration timing. Why D is incorrect. The FECA concerns campaign finance, not voter registration. This question covers election accessibility versus fraud concerns. Question 27. During the introduction of new methods where coordination is essential, a state transitions to all-mail voting. A legal challenge argues that mail voting increases the risk of ballot harvesting and fraud. Which constitutional provision allows states to regulate voting procedures? A. 10th Amendment. State sovereignty. B. Article I, Section 4. Elections Clause. C. First Amendment. Freedom of Assembly. D. 14th Amendment. The Equal Protection Clause. Answer: B. Article I, Section 4. Elections Clause. Explanation: why B is correct. The Elections Clause gives states authority over the times, places, and manner of elections. Why A is incorrect. The 10th Amendment reserves general state powers but does not specifically address elections. Why C is incorrect. The First Amendment protects speech and assembly, not voting methods. Why D is incorrect. The 14th Amendment applies to fairness, law enforcement, but does not regulate voting procedures. This question examines state control over election methods. Question 28. In a scenario where efficiency decreases across multiple jurisdictions, an election commission discovers that some states take days to finalize vote counts due to outdated systems. Which federal law sets standards for modernizing election processes? A. Help America Vote Act, HIVA. B. Voting Rights Act, VRA. C. Federal Election Campaign Act, FECA. D. Electoral Count Act. Answer: A. Help America Vote Act, HIVA. Explanation: why A is correct. HIVA provides guidelines for updating election infrastructure and reducing delays. Why B is incorrect. The VRA focuses on voting rights, not efficiency. Why C is incorrect. The FECA governs campaign finance, not election processes. Why D is incorrect. The Electoral Count Act addresses the presidential election process but does not regulate vote counting efficiency. Question assesses election modernization and efficiency. Question 29. While examining inconsistencies across various units, a state legislature proposes a new voter ID law that requires specific forms of identification. Some argue that this disproportionately affects low-income and minority voters. Which constitutional amendment is most relevant to evaluating this claim? A. First Amendment. Freedom of speech. B. 14th Amendment. Equal Protection Clause. C. Second Amendment. Right to bear arms. D. 22nd Amendment. Presidential term limits. Answer: B. 14th Amendment. Equal Protection Clause. Explanation: why B is correct. The Equal Protection Clause of the 14th Amendment ensures that laws apply fairly to all citizens. If voter ID law disproportionately affects certain groups, it may be challenged under this clause. Why A is incorrect. The First Amendment protects free speech but does not directly govern voter ID laws. Why C is incorrect. The Second Amendment deals with gun rights, not voting rights. Why D is incorrect. The 22nd Amendment limits presidential terms and is unrelated to voter ID laws. This question evaluates constitutional protections against discriminatory voting laws. Question 30. During an emergency response where multiple areas are impacted, a state decides to change election procedures due to a natural disaster. Critics argue that the changes are unconstitutional because they were not approved by the state legislature. Which constitutional clause is most relevant? A. Supremacy Clause, Article Elections Clause, Article I, Section 4. C. Commerce Clause, Article I, Section 8. D. Takings Clause, Fifth Amendment. Answer: B. Elections Clause, Article I, Section 4. Explanation: why B is correct. The Elections Clause gives state legislatures the power to regulate elections. If election procedures are changed without legislative approval, they may be unconstitutional. Y is incorrect. The Supremacy Clause establishes federal law as supreme but does not regulate election procedure changes. YC is incorrect. The Commerce Clause deals with interstate trade, not election law. YD is incorrect. The Takings Clause addresses government seizure of private property, not voting laws. This question explores state authority over election laws during emergencies.